Hello, nice to see you again. Okay, we will have to start the session in about 2 minutes. So it's a 2-minute warning, please. So those of you outside the auditorium, please come in. And those of you who are coming in, please do take a seat. We have an incredible panel. So, you know, 6 incredible panelists and Justice Sri Krishna as a further double hatter. So, you know, we'll just wait a moment. Okay, we're going to make a start now, so that we look to run to time. And I would encourage, because I know this mic is also being fed through to the lunch area. So please, those of you listening to me giving you this further request, please could you come into the auditorium, because we're going to start, and you don't want to miss this panel. This panel is going to be quite something, so I would encourage you all to come in. So those of you who are in at the moment, thank you very much for gathering. This is one of the highlights for me of any GAR live conference, and I'm honoured to be able to co-moderate this session with Justice Sri Krishna, who, as you know, is my co-chair of this conference. This is the arbitrator's question time, an opportunity for us to delve into the minds and thoughts of the arbitrators who are on this panel, and a really wonderful group, and I'm going to briefly introduce each of them. You will know them, and they span a number of geographies, which is another great thing about this panel. There's a lot of knowledge, experience, and expertise on this panel. Before I introduce the panelists, I'm going to just briefly talk about the structure of this session. So what we're going to do is I'm going to ask, on behalf of Justice Sri Krishna and myself, a question of each of the arbitrators that I told them about half an hour ago. Okay, so we wanted some spontaneity, so they've only had half an hour notice. In the case of VK, because he was on a call, he doesn't know the question I'm going to ask him, and nor does Shreyas, which is even better. It adds to the spontaneity. Then there are going to be 6 further questions that they don't know about. So again, spontaneity is the name of the game. And then David Brynmor Thomas, who I will briefly introduce to you in a moment, came up with a wonderful idea for how we should have some further questions, because we were obviously going to open it up to the audience. But David had a brilliant idea, which was that for the very first section of the audience questions, that 10 minutes of that question time or so will be allotted first to lawyers in the audience of 10 years experience and below. And because we want the younger generation to be asking questions up front, okay? So please think about questions. Everyone on this panel is delightful. No one's going to be breathing fire, so please feel free to ask them questions. That's how we get the most out of these interactive sessions. So, and of course, Justice Sri Krishna will obviously also be very closely involved. I'm standing up mainly because we haven't quite got space for 8 chairs on the stage, and also because it's nice to feel like a lawyer now and again and stand at a lectern when I'm addressing people. So, okay, now let's jump in. I'd like to introduce very briefly our very distinguished panel of arbitrators. And I should also say, before I begin, that Justice Sri Krishna is, of course, a very eminent arbitrator himself, although he's not officially a panelist amongst the arbitrators. So, beginning on my far left is Sitpah Selvaratnam, a full-time arbitrator based in Kuala Lumpur in Malaysia. She had a very long and distinguished career in private practice and has very recently become a full-time arbitrator. And those of you who were at the International Women's Day event yesterday held at JSA's offices will know that Sitpah delivered the closing remarks, and they were quite something. And I think Kevin Nash of SIAC, who I'm not sure if Kevin's here yet, but Kevin was speaking for many when he was singing Sitpah's praises. Next to Sitpah is Justice Akil Kureshi, former Chief Justice of the Rajasthan High Court and a former judge of the Bombay High Court and the Gujarat High Court, and now in arbitrator practice. And it's a great honor to have a distinguished former Indian judge on the panel, another Indian judge on the panel. Next to Justice Kureshi is VK Rajah. Now, VK, as I'm sure you all know, again, has had a very distinguished career. After many years in practice, he was a judge of the Singapore High Court, the Singapore Court of Appeal, and then was the 8th Attorney General of Singapore, and stepped down from that role in 2017, and since that time has returned to the private sector as an arbitrator. Next to VK is Shreyas Jayasimha, who again, many of you based in India will know, many of you based outside of India will know. Shreyas is an arbitrator, a counsel, a very fine lawyer who I've had the pleasure of knowing for many, many years. He's a thought leader, and from a very long time ago, realized that dispute resolution doesn't have to just be about fighting. It can be about resolving disputes. And he's also a real leading light in the world of mediation. So great to have you here with us, Shreyas. Next to Shreyas is Sadaff Habib, based in Dubai, but as we've spoken, is very proud of her Indian heritage. And Sadaff is one of this incredible new generation of arbitrators. And I've said this before, you can't steal my joy when I see people like Sadaff breaking into the world of arbitration, not least because she is a female arbitrator of ethnic origin. And there are far too few of those in the world. So it's lovely to see Sadaff. Sadaff is an independent arbitrator and the founder of Equanimity Arbitration, based in Dubai. Next to Sadaff, we have David Brynmor Thomas, a KC. Again, a very dear friend, a King's Counsel at 39 Essex Chambers in London. David has not just got a stellar practice, he's got a stellar CV. There are very few people, genuinely, I would say, who can say that they could have on their CV the following accolades or titles. First of all, medical doctor, then became a solicitor, then became a barrister, is also an arbitrator, and is also an academic. He's a visiting professor at a university in London. So quite a distinguished CV by anyone's standards. And of course, everyone knows Justice Sri Krishna. And so we will be co-chairing this, but I've asked, and he has very kindly agreed, to also make a few comments here and there to supplement anything he wishes to supplement from our great panel. So on that footing, we're going to jump in. And we're going to go to the first question. And my first question on our behalf is to Sadaff. And it's this. What is the biggest challenge about being an arbitrator?
Thank you very much, Gautam, and thank you, Justice Sri Krishna, and obviously thank you to GAR for having us here today. So when Gautam told me about this question, I was like, wow, I can think of so many different things. But I realized that if I was to name one particular thing, I would go back to, so I call my practice equanimity arbitration. Now, the reason being, I wanted to remind myself when I set up as an independent arbitrator to maintain this calm and composed mindset, hence the term equanimity, because that's what the essence of the word is. Because when you're sitting as an arbitrator, sometimes you might be presented with, let's just say, challenging submissions or evidence that might be incomplete, and there'll be something in your mind that will be shouting and feeling really sorry for the client who's being represented by the counsel. But you need to step back, you need to detach, practice this set of detachment from the case, and to maintain this because obviously as an arbitrator, the idea is you're impartial, independent, and so you're unbiased. But that is not strictly in the sense of favoring one party. It's also in the sense of not reacting and not getting annoyed and, just keeping your emotions, setting them aside. But thinking about it, taking it even broader, if I may, and just looking at it as a challenge to the greatest challenge to the arbitration community and the legal community, I would say the legal fraternity. To that, I would say it's this idea of burnout. I mean, the amount of lawyers, the amount of arbitration practitioners, the amount of professionals that are pushing themselves beyond a point, it's heartbreaking to see, because I feel that we really need to reassess where we're headed, and that change starts within us. So each of us need to learn how to say a positive no. Each of us need to understand our limits and where we are pushing ourselves to the extent that we're compromising our client's needs. And if you're compromising your client's case, then obviously that's going to affect the arbitrator as well. So there is this, and I have spoken to, in the past few days, I've spoken to certain lawyers and advocates, and I realize there's a lot of pressure, not just on, it's just general, it's global. It's a global pressure, it's a global phenomenon that we're facing. Hence, we're constantly talking about mindfulness and mindful practices. But the thing is that we need to create space. I mean, if I can just make one closing remark, which is, we had International Women's Day, and the theme for International Women's Day was to inspire inclusion. Now, to me, inspire inclusion means to actually create space for our entire human experience, whether we carry the hat of a lawyer, arbitrator, counsel, advocate, whatever it may be, client. We need to create that space for our humanness, and our humanness includes embracing emotions that are perceived as not so positive. So the idea of inspiring inclusion is not just to increase diversity in the sense of race, gender, or creed. It's also to create room for our entire experience. How that would fit in practically in terms of the legal profession, I think is something for all our legal brains and for us to put our minds to. But I would say, I know I've made these comments and I've deviated a little bit from the question in terms of the challenge to the arbitrators, but it does, if you really think about it, if you're not performing at a level where you're doing justice, not just to the case, but to yourself, it will impact your work. And eventually you will be compromising your client's case, which ultimately will then affect the arbitrator, because don't forget your arbitrator is a human being as well. So I'll leave it at that.
Thank you. Thank you, Sadaff. My next question is to Sitpah. Now, one of the other interesting facts that I should, and there is a method to this, is that Sitpah and Sadaff are both martial artists. To add to their many accolades, and Sitpah is a black belt, so I'm always very wary about the questions I put to Sitpah. But no, so Sitpah, I want to ask you this question. How do you deal with difficult co-arbitrators?
All right, thank you, Gautam. Thank you, Garth. Thank you all for including me in this program this whole week. So I'll preface my answer by saying I haven't actually had a difficult experience. I've had tense moments, but I've been lucky in the 15 years. But of course, I go in prepared for having a situation that might not be too pleasant. But I would say this, once you've gone through the pathway of being a litigator, then you've gone through situations where you've dealt with hostile witnesses, antagonistic opponents, difficult judges. So you develop a sensitivity. Your persona naturally shifts when you sense some kind of aggression from another party. And so you naturally shift gear. And I would say, if in all our cases, the reputation of the arbitrator precedes them. The good reputation, the bad, and including the reputation of being dominant or being a bully, and so on. So if I know I'm about to enter the arena with one of those personalities, then I have my right persona on, which is very firm, but kind, and that sort of preempts any difficult situation. So it could be my martial art training, it could be, but it has worked all this while. But we, of course, have differences of opinion on issues, and that's perfectly healthy. That's the whole point of having a 3-member panel, to have different perspectives. That's fine. And so when that happens, and so far I've always been in a situation of a unanimous decision without having to compromise my intellectual honesty. And so what it does take then is to be able to embrace the other person's perspective, think about it, mull over it, let them feel that they've been heard, you be heard, and do what it takes to be heard, and then we will land somewhere amenable. And that's been my experience, Gautam.
Thank you, Sitpah. I'd like to invite Justice Shri Krishna to make some comments.
Ask you a question, both of you. As an arbitrator, you come across recalcitrant, bull-headed lawyers who make it difficult for you to carry on with the proceedings. Now, you are right. Your reputation has preceded you in the sense that you are a very fair-minded arbitrator. You are well-learned. You are well prepared with it. The fact that you are a black belt, has it also preceded and made them keep quiet?
I don't think...
excuse me for a moment. Pardon me. If I were ever a lawyer and I came to you wanting to disrupt your proceeding, somebody told me this lady is a black belt, I would shut up and be very quiet.
Judge, until today and until Gautam made this public opinion, public knowledge. I think until today and until Gautam made this public information, no one knew I'm a black belt. So
This goes around. This unsaid things about a judge and an arbitrator are well known. Nobody publicized it. It's Chatham rules. We all know what it is. We all know the lady is a black belt and we keep quiet.
Okay, thank you. My next question is to David. So David Brynmor Thomas. Should arbitrators be full-time arbitrators, or is it good for them to also act as counsel in separate cases?
I'm sitting next to two full-time arbitrators who practice martial arts, and I don't practice martial arts. But it's a more serious answer. I think arbitrators can be full-time, and there's a great value in that. And many of us who practice as arbitrators foresee a time. I foresee a time when I will end up as a full-time arbitrator, but I have a mixed practice at the moment. And I think that workers' counsel at the same time can be of great value. I think that having practiced as a counsel, as a litigator, is of enormous value, whether you're a full-time arbitrator or not, because you start to have an idea of what counsel are doing. And I sometimes I say there's a dynamic in any arbitration. There's leading counsel or first chair counsel for the claimant, there's leading counsel for the respondent, and then there's the chairman or the chair or the chairwoman or the president's best term. And the three of them are fighting for control of the room. And then, depending on who the co-arbitrators are, some of them may be fighting for control of the room as well. And I think that experience as an arbitrator, knowing what counsel is trying to do, is invaluable, whether you've got that because you practice as a counsel still, or because you have done so. You sit there sometimes, I know exactly what you're trying to do. I think the more relevant point is being an arbitrator should be something you do seriously. What I mean by that is, full-time arbitrators obviously take their role seriously. Those of us who have mixed practices, for me, it is a significant part of my practice. It's about 25% of my practice. What I would criticize or deprecate is people who say, oh, well, I do lots of things. I'm a law firm partner, I practice as a litigator, I practice as an arbitrator. Oh, I've been offered one arbitration. Oh, that would be quite fun to do. And I'll do one, and then I might not do another one for 4 or 5 years. I think that's a mistake, because you do have to have a mentality, and the only way you can develop the mentality of being an arbitrator is by doing it either full-time or as a significant part of your practice. And what I would say in relation to the sort of significant part of my practice, when I say 25% of my practice is as arbitrator, that's because I find if that proportion creeps up, counsel work and arbitrator work starts to interfere with each other. So I keep my practice at about 25% of arbitrator work because I can maintain that balance. If it gets up to 50-50, I find that balance becomes difficult to maintain. But you can be either, you can have a mixed counsel practice or a pure arbitrator practice, but it's got to be something that you identify yourself as being. It can't simply, in my view, be something that you do once in a blue moon when it crops up.
Thank you. Sitpah, do you want to make something?
Could I just chip in there?
Please.
I think, well, absolutely correct. For once, we are agreeing, David. But I would also say this. I think in this day and age, there is a greater space for generational diversity, and we want to really encourage the younger generation of trained arbitrators, trained in every sense of award writing and everything, how to conduct an arbitration fairly and equally, to participate. Why? Because they are having the ear to the ground, to know what the industry wants. They have the hand on the pulse of what the users expect and demand. So it's very important to have that that version or addition of arbitrators within the field as well. And you cannot expect them to dive headfirst into the pool of a full-time arbitrator. They must be able to test it out, see whether their personality suits the role, and maybe it's too much of financial risk for them as well. So I think it's horses for courses, whatever suits the career cycle of an individual and what suits their personality.
Thank you. Yes, Shreyas, please.
This is a topic of some interest to me because I've been an objector to Unsit Charles' approach of saying there's a analogy, which I think is a false analogy, of hats when it comes to playing the role of a counsel or an arbitrator or a mediator. And I have failed utterly in trying to say that that is an absolutely incorrect analogy. The more correct analogy, according to me, would be felicity with languages. Just because one language is spoken, it doesn't mean another language cannot be spoken well. Or perhaps that of intelligence itself. Just because one is bestowed with IQ, it doesn't mean absence of EQ. But I join voice with what David said, is that whatever analogy you choose, that it must be pursued sincerely and fully is critical. But I fear that there will be some years gone by before the world course corrects from, I don't know where this, whose hat, the idea of hat came from, but it is wrong.
I think hatting, double hatting, came largely from the investment treaty space, with the Telecom Malaysia case initially, when Manuel GAR had to resign from either being counsel in one case or arbitrator in another. He was given the choice by the Dutch court. And I think the issue is the way in which public treaty cases and treaty awards get picked up, understandably by GAR and by others, because they are published, whereas private cases aren't published. And so people end up writing on issues, and there are certain issues in public international law that are quite limited, and also because there isn't authority and precedent, what somebody has written in that public international law space is relevant. So what Emmanuel GAR had written about, I don't know, fair and equitable treatment or whatever, was then relevant when he turned around and tried to, and was seeking to argue it. He was arguing it in one place. If you could get a decision in one way, it would be relevant and transferable. Frankly, in private international arbitration, the same issue doesn't arise. There are issues around the way in which you treat extensions of time in construction contracts, but my opinion on the formation of contracts under English law isn't remarkable. It's a pretty well settled issue. How someone approaches the construction of a contract doesn't really, I don't have the chance to write the pen, to hold the pen, and then cite it as an authority or something that should be followed. It's just my approach to construing a contract. So that double hatting, I think, is one of the ways in which issues that have arisen in the public international law space have washed into private international arbitration, not necessarily to our benefit.
Yes, Sadaff, please.
David, I think you made a very good point about, actually just going back to what you first said, about an arbitrator being serious about being an arbitrator. And the second thing that you said was when you have individuals, and not necessarily just lawyers and arbitrators, but who are doing multiple, are involved in multiple projects across the arbitration community. I mean, kudos to that, but I feel that two things come out of that. First of all, parties need to really be careful when they're selecting their arbitrator. Not just look at these are, the prominent players in the market and we're just going to go with that. But think about it in terms of the person's availability, their capacity. And the second thing I would say, the onus is also because each of us, when we accept a case, we have to sign a declaration of independence and acceptance, and we have to say that we're available to accept the appointment. And I think this idea, because the benchmark for arbitrators is to act with integrity. Now, integrity obviously has many aspects to it, but I feel one of them is also in accepting a case if you can do credit to it and act seriously. That's all I would say.
No, thank you. No, it's great. No, it's really good to have different perspectives, because we do like these questions to raise organic issues amongst the panel. So thank you for those thoughts. My next question is to VK, please. Now, VK, this just shows the spontaneity, as we know, is a very good thing. I didn't get a chance to tell you this question, so this is the first time you're hearing this. What one reform for you would make arbitration a better process?
I think the most important issue that will and to some extent has affected arbitration is ethics. Ethics not just of counsel, but ethics of arbitrators. And it is critical that we find a global mechanism to enforce it for across the board. The desire to win cases, the desire to do right by the client can in some cases, fortunately, I must confess, and immediately caveat this by saying this happens to my mind in only a small minority of cases. But even then, it is not good enough. So let me first look at the issue nationally and then globally. So there is no mechanism now, even if a counsel or a group of counsel misbehave, to set the situation right. The arbitrators can lodge a complaint, but that's hardly ever done, because if you complain, it would have to be to the domestic regulators of that particular council. And then you would have to be a complainant and to give evidence. And no arbitrator wants to get involved or tangled in that mess. So that's as far as counsel are concerned. But we have another problem with arbitrators themselves. There are stories not peculiar to India where arbitrators give reference fees, arbitrators market themselves, and arbitrators, and again I want to say, this seldom happens, can sometimes retain a degree of partisanship. Let me give you an example. I chaired a session, and in the course of the proceedings, it was clear to me that one of the arbitrators was being partisan. He was effectively cross-examining both the witness and counsel for the opposing side, the side that didn't appoint him. And I was concerned because if this was allowed to go on, this would not just taint him, it would taint the entire process. I called for adjournment because I didn't want to say anything or stop him in front of the tribunal. I told him that if he continued, I would stop the questioning in public and disassociate myself as well as the co-arbitrator from his questions. And he behaved impeccably after that. Now, so I'm not sure what this would have happened. I'd like to think anyone else in my position would have done exactly the same. So we need to have global rules, global standards. And the IBA has made considerable progress over the last decade or so in terms of conflicts and some other issues. But we need to have rules that all of us in this field, given the increasing numbers that are participating, that all of us can subscribe to. And here, may I suggest that India can take the lead. Now, you've got practically white space. There are very few rules. I know you have incorporated some rules into your domestic legislation, but they are hardly ever enforced. I think global thought leadership is required in this area. And this is where, instead of waiting for the rest of the world to fix it, a country, an institute, groups of individuals or institution can take the lead.
Thank you, VK. Next question is going to Justice Kureshi, please. Give us a few things which you wish counsel would not do when they address you in a case.
Thanks. Thank you, Gautam. Thank you, Justice Shri Krishna, for inviting me here. In answer to your question, exactly the same three things which I would not want lawyers to do in my court, and which are not argue with each other. Every time they try to argue, I said, are you trying to convince your opponent? You have to convince me. Why are you trying to convince him? In fact, when I came to Bombay, I saw a pattern where both counsel are standing up and sentence to sentence they, exchange banter. And I said, no, this is not how it goes. The petitioner's counsel argues, the respondent's counsel argues, rejoinder, and then my role starts. So no arguments internally, continuation of the same thing, no aggression. So much of waste of time, bickering and quarreling internally. It's completely useless. Everybody is doing his own job. So just do your job and let me do my job. 2, I would not want arguments to be circuitous or meandering kind of arguments. It has to be in a straight line, precise, and in compartments. Mostly I would request the counsel to outline the contentions which he's going to raise, write them down, and he can make good those contentions one by elaborating. So all over the place arguments really does not help. And lastly, not be very difficult about finding the next date. You know, the same way arbitrators are sometimes criticized for taking too much work and not available dates with them. The advocates also sometimes end up doing the same thing. So I would want a lot more cooperation from the lawyers to give quick and shorter dates. These are the 3 things mainly I would require the lawyers not to do with me. Thank you.
Thank you very much. Thank you. Last and definitely not least, a question to Shreyas. Do you think retired judges are a help or a hindrance? The present company accepted, of course.
Well, answering the question for sitting judges, answering the question in the company of several retired judges, being the son of a judge as well. Thank you, Gautam. But let me say this, that, I think with longevity, the time in which a lawyer is expected to spend on the bench seems a little out of whack with contemporary healthcare and biology. So the time at which persons are asked to retire from the bench, whether in India or elsewhere, except systems like the United States, is fairly premature. And an individual, a woman or a man, is endowed with tremendous experience, has to display their prowess and acumen in public on a daily basis, and they operate under a harsh limelight. Not every judge is a popular arbitrator. And it will always be so. That bridge cannot be met by publicity or referral fees or anything else. And so, in that light, I would like to perhaps controversially say that the prior occupation of a potential arbitrator should become irrelevant. There should be neither an obsession nor an aversion. And using that, let me shine the light on the whole communities that are today being ignored. There are professionals who may be statisticians, they may be financial experts, they may be domain experts. The famous Toby Landau statement of judgeitis or lawyeritis occupies the mind most severely at the time of thinking of a potential arbitrator. So I hope diplomatically I have avoided the bullet.
Well,
Can I?
Yeah, no, please, yes.
Yes, sir.
Can I jump into it? Having been a practitioner of law for 28 years at the bar, spent about 16 and a half years on the bench, and let's say last 18 years as an arbitrator, I intend to agree with you that judges actually have made this unnecessarily complex. Because ultimately, what is arbitration? Arbitration is supposed to be a simplistic thing, which, if you go back to our panchayati system, what do you want to say, what do you want to say, here is my order, finish. That was what it was intended to be. Now, I think Russell somewhere has said that if you want to know what is the right way of placing this brick in this construction, ask the bricklayer, he will tell you he is the best judge. No, Lord Chief Justice will not know about it. Same thing, if you want to know whether a diamond is good or flawed, you ask the jeweler sitting in Chickpet or Nagarthpet or wherever, and in 2 minutes his son will tell you what is right or wrong. Now, unfortunately, what has happened is this was what arbitration was intended to be. Now we have made it so complex with so many laws and so many, reports, which make it more and more confusing to everybody, including the report writers themselves. Sorry, I'm not being personal. So this is what has happened. We have made it unnecessary. It's made unnecessarily complex. Now, of course, law will say, hey, look, as a judge, you had assessments, assessors available to you, experts, evidence. Now, please, you have an expert on diamond industry coming and telling me something, another expert on diamond industry. Ultimately, I ask my wife and say, whom should I believe? And I do it. This is the unfortunate thing. But if I were to sit there as a known person with some knowledge, modicum of the thing, it would have been simpler. But unfortunately, that doesn't happen. I'll tell you my example. I was sitting on a construction civil construction of a defense contractor. And one of the reputed engineers, former engineer, was there. And he told me, what is so difficult about it? It's simple. This fellow says, he had written me 100 letters saying that I want time for this, I want time for this. On that basis, we should grant him time. I said, where are the letters? You know, he has written to me already. I said, mister, if he wrote to you your letter and it is not a part of my record, if I were to rely on that, having been a judge, I'll be called a BF. Mm-hmm. So now this is where we get into problem. Had I not been a judge, I would have gone with him and say, he's already written to you, chalo, let us grant him trade. This, exactly, last one point, this difficulty arises because the difference between a man who is married and a man who dallies. The man who dallies has so many girlfriends. The man who is married once for all, like me for 54 years, no chance of doing anything else. Now, therefore, it will be a hindrance.
So I want to just jump in back to VK's point because I think there's a lot of ancient wisdom that's untapped, and you're precisely right. India should lead in this. For example, there are portions of the Hadith that say when should a neutral be ready to judge? Have they had breakfast? Have they fought with their spouse? If they have fought with their spouse, they should consider themselves ineligible because they lack equanimity. So the source of notes of arbitrators that LCIA and a few ICC and others have to be augmented with ancient wisdom. This civilizational high shoulders that we stand on cannot be ignored by claiming that we're in 2024 and therefore we are modern. This ancient wisdom is perhaps what can be tapped to address the point that VK made and the prior point.
No, you are right. You talked about hadiths. You look at any of these samhitas, Yajnavalkya Samhita, it will give it exactly. When the witness comes into the box, how do you determine that he's good or bad? How do you determine he's seeking truth or not? And of course, the fact that you had a quarrel with your wife in the morning, over breakfast or otherwise, will also enter into the picture. And that is what is called the inherent bias. I mean, the AI will detect it one way or the other, but otherwise it is not possible.
Can I just add on?
Please, yes.
I've sat with retired judges. I've sat with those who have never held public office. And I must say, at the end of the day, it's the conscientiousness of the person sitting that matters, not the past. Past is not prologue. The fact that you're a retired judge is not a pre-qualification. At the end of the day, it's the person. And I've just had the privilege of sitting with two, and seniority is not a disadvantage, because I sat recently, 2 weeks ago, with retired English Supreme Court judge and a Court of Appeal judge. And they had covered every single document. And I can't say that many other arbitrations that I've sat with, the co-arbitrators or others had displayed the same conscientiousness. So the point I'm trying to make very simply is, and I'll be very direct with you, that, and I'm not the first to say this, there is a cultural obsession with appointing retired judges in India. I'm not suggesting that it is wrong, because you've got some extremely able people who continue to manifest those qualities today. And I can say from what I've heard, that includes the present company. But again, there are also some exceptional Indian lawyers, 40s, 50s, and the 60s, have never been judges, of exceptional minds or people of great integrity. And they should receive more acknowledgement, and that's the only way you're going to get Indians being counted among leading arbitrators in the world. They need a track record, they need a runway. They need to build that expertise over 20, 30 years. And I have met many who tick all the right boxes. That's your future.
Just one small, very quick comment on this. Somebody once asked, what is ailing Indian arbitration system? And the answer came was, current judges and former judges. So we all desire that outside thoughts and outside blood comes. But why is it still that overwhelmingly we are still opting for former judges? And my take on this is that because you have seen the person work in public eye, public domain for 10, 15, and 17 years, you have seen him pass the test of handling sensitive or tense situations. People have vouched for his integrity. And all that is known. And therefore, though there are a large number of judges who are retired, not everybody gets the same attention. And therefore, a few of them who have passed all these tests do get more focused. And therefore, those who have not been in such kind of a scrutiny, they have to have some mechanism from where they can show it. Their integrity, their ability to handle difficult and tense situations, and their ability to deliver good judgments. If we can do that, we'll be able to break through and include outsiders other than former judges also.
David.
Very quickly. There are 3 retired judges on this podium, so I'm not breaching any confidence when I say that I have sat with 2 of them, because you don't know who's the odd one out. The 2 retired judges on this podium who I have sat with were wonderful to sit with. And they were wonderful to sit with, and it comes back to VK's point. Neither of them sat as retired judges. Each of them sat as an arbitrator and conceived of themselves patently as an arbitrator. And I think that the point that's also made by Judge Kureshi is people who have been judges are very well qualified to become arbitrators. People who've been senior lawyers are very well qualified to become arbitrators. People who've held senior positions in other industries are very well qualified to become arbitrators, but the good ones conceive of themselves as arbitrators, not what has gone before.
Thank you, David. I'm just going to take a moment to just because Justice Srikrishna, apart from being my co-chair of this conference, is also a great mentor and teacher to me. And the benefit of being a mentee is I get to pull his leg now and again. And he mentioned his wife, Mrs. Srikrishna. So since it is still International Women's Day in Hawaii, and those of you who heard my opening comments this morning would have heard my reference and what I said about International Women's Day and the importance of women and their empowerment and their achievement. I just want to make a couple of comments. One of the most wonderful things I'll never forget that Mrs. Srikrishna has said on record, and in fact I've teased you about this before, is when Justice Srikrishna was a sitting judge, she said, yes, he is a Supreme Court judge, but I'm the Chief Justice of our domestic court. And I think you can't better that. Also, in continuation of the International Women's Day theme, and it is still only about 10:15 in the evening in Hawaii on the 8th of March, so I am being absolutely on point here. There is a wonderful initiative in India that has been begun, not just for Indian women, but Indian women working abroad in arbitration, called Indian Women in International Arbitration. A number of you will have heard of it. One of my colleagues at Reed Smith founded it. Ahuja, who's here today. It's a wonderful grouping. I would encourage you all to please find out more about it and become involved in it. I just one little comment further about my very cheeky question about retired judges. I've been counsel in cases where there have been retired judges and non-judges. There's one particular retired judge, I won't name him, but David and Richard Wilmot Smith will be very familiar with him. I've had two cases where he's been an arbitrator, absolutely meticulous. The best prepared of all three arbitrators, the most courteous of all three arbitrators, and always asked the best questions. And you'll know who that arbitrator is, because he's one of your colleagues at Chambers. Right, now we're going to move on. Now, as I said at the beginning, I had some other questions which I wanted to, out of pure spontaneity, throw to our great panel. I'm going to abridge that and ask one question and ask two arbitrators to briefly comment on that question. So we'll truncate that because we want to get the audience asking questions. And those of you who heard my opening will have said, when I opened the questions to the floor, when Justice Sri Krishna and I opened the floor to the audience, the first 10 minutes of those questions is reserved only for lawyers of 10 years or less experience. So please, I've given you fair warning, so please think about questions. Okay, now, I've got three questions, and I'd urge each of you in pairs to briefly comment on it, each of these points. So my first question is addressed to Sadaff, who to please comment first, followed by David. Can we ever have fully green arbitration?
Oh, are there any activists in the crowd?
Can we ever, I'm sorry, you didn't hear.
Okay.
Yes, can we ever fully achieve green arbitration?
Okay. See, the thing is, we are headed in that direction. I mean, you have, nobody's using hard copy bundles anymore on a very simplistic basis. You know, you're not asking the parties to give you hard copy submissions. Now, it depends to what extent you take this idea of full green arbitrations, because the biggest sort of carbon emissions come when, you know, you have to fly long distances and attend hearings and that kind of thing. There are advantages to having an in-person hearing. I'm sure my colleagues might agree. But there are also, I think it's a case-to-case basis. It's a very, I can see us heading in that direction. But how soon we're going to get there is difficult to say. I mean, you do have AI and you have all these creative platforms at the moment going on with providing you all sorts of services to facilitate the arbitration process. But whether that will be whether that will fully result in a green arbitration, I mean, that would be wonderful for the trees. But I don't know, actually. Yeah.
That's fair enough.
Can we ever achieve green arbitration? I think, can we ever achieve a definition of what green arbitration actually is? I don't think we can know exactly what that is. If you mean, can we ever have a zero carbon arbitration? The answer is no. Even if it is run by AI, the AI will be being run on some huge server in California and will be taking electricity. It's like the fact that Bitcoin is not carbon neutral. So even those things don't become carbon zero. Can we have a carbon neutral arbitration? Quite possibly. But again, it depends on what you look at in terms of the emissions. People who do sort of energy work and transition work will know the different classes of emissions. And so we can have something that is frankly sort of carbon neutral, like the UK, the trick that the UK is pulling. We're being very, very aggressive in terms of carbon neutrality. But then when we import stuff that's manufactured elsewhere, and we don't count the carbon emissions that have gone towards that, then that's not really so good. The flip side of that is, if arbitration and in-person arbitration is necessary so as to facilitate investments in renewable energy sources. I've done some very, very, very big solar projects, and I've got a very, very big wind project coming up. Now, if the investment for that, part of that is that every so often we arbitrate those, then we're still contributing to the energy transition, even though a specific hearing generates some carbon. I mean, certainly since COVID, since the pandemic, I don't think I've done an in-person procedural hearing since then. So we've moved that way. But yes, first I think you'd have to say what exactly the definition is. Real lawyer's answer.
Thank you. Okay, the next question, I'll please ask each of Sitpah and VK to briefly address this point. Do we have too much due process paranoia in arbitration rather than robust case management?
I'll go first because then I'm sure BK will mop up on that, on whatever else I miss out. I think it again depends on the selection of the arbitrators. So it can't be generalized. We've got very robust arbitrators who in fact can swing the other way. And sometimes we worry whether party autonomy is being compromised about it. But of course, you do have the situation where we are careful of ensuring equality, fairness, adequate hearing opportunity, adequate presentation. I am not convinced that there's too much paranoia in the present system.
I just wrote a couple of years ago a 50-page article on this, so I'm not going to try and summarize that. I'll just make two observations. First, how the term was coined and how it took off. And I dissected the Queen Mary University analysis to show that it was perhaps misplaced because most of the respondents were, if you analyze the figures later, were not necessarily practitioners. They came from a variety of sources. So obviously certain panels will be cautious about giving procedural fairness. But I agree with Selvaratnam that at the end of the day, it depends on the experience of the panel. It depends on their knowledge of what due process of the seat requires and the actual challenges manifested. The perception of undue due process paranoia came about because some tribunals were more open to giving adjournments and giving time, and that led to unhappiness. But I think there's a growing awareness among both counsel and tribunals that adjournments will hardly be given. And the most encouraging trend is globally that most courts, in fact, all the major seats, will defer to the tribunal on such issues. And I think that has helped to tamp down the issue of due process paranoia. And you would notice that the Queen Mary surveys that followed the 2014 survey have dropped that term. So in a way, I'm not saying that it's gone away, but I think it was overemphasized.
Thank you. Thank you. Okay, last question, and then we're going to open the floor. So please think about those questions. Okay, this is going to be obviously to Justice Kureshi and to Shreyas. When will India become a true arbitration hub? Please.
When we can sort out the problem of court backlogs from starting, in between, and the end, arbitration gets locked into court processes. Section 11 appointments take sometimes a year and more. It's completely destroys the purpose. Executions take a long time. Challenges take a long time. So no matter what we do about the arbitration itself, unless and until the courts are able to devote sufficient time to deal with arbitration-related issues will not make a headway. The entire thing boils down to courts are overwhelmed by pendency of cases. It is impossible to tell the Chief Justice have dedicated judges for arbitration because every jurisdiction asks for dedication. Criminal matters, tax matters, arbitrations. So unless and until we have sufficient time to devote to arbitration matters in a quick manner, all our efforts are going to fail.
Thank you. Shreyas?
You need an internationalization of all access to all stakeholders. You need international firms to feel free, not be bound by tax worries or any other worry to participate. You need arbitrators of international repute to be able to feel comfortable to sit, not be met with anti-arbitration injunctions or other threats that will stop them from behaving independently and impartially. You need greater concern by the parliament, by the executive, by the judiciary, with all due respect, to also see ourselves as a civilizational state, not merely as a nation state. There are civilizational values that we can contribute to. And in that respect, I think we are failing. India is failing in the expectations of its true potential by not making this a urgent priority. In recent times, I have heard a cynical comment from very dear friends as well to say, India should just give up. We should stop going on about wanting to be an arbitration hub. We should just be satisfied with retrieving a few Indian party-involved international arbitrations back into India. I disagree. India should continue to will towards it, aim for the stars. Where we will land up, time will tell, but the aim should not be any less. And I think there can be, in due course, an international court with international judges. Some of this might require constitutional amendments, but that is the future. In 1950, international law was not as important as it is today in 2024. And if where we want to go is $50 trillion in 2030 or 50, we need a far greater and confident openness at all levels.
Thank you very much. That was a wonderful session. Thank you very much for that. Now, that's the end of me asking you questions. Now it's going to be opening up to the audience. So could I request, I see there's a taker there right next to Richard. What we're going to do is we want to get as many in as we can. So what we're going to do is, could the person asking the question please give their name and where they work or where they study, as the case may be, and then we'll aim to share the questions out. We'll have one arbitrator answer the question, so we get as many of them involved in the questions. Okay? Please. Yes, the young lady next to Richard first, please. And then, please.
Good evening, everyone. I'm Nishtha Jain. I work at Chambers of Shashank Garg. My question is for Mr. Rajah. If due process is a function of the view of the enforcing court, where does an arbitrator go to find the attitude of the enforcing court to what is due process?
Well, the first instance would be writings, both by judges and also by academics or practitioners. And all the leading arbitration seats have got an abundance of commentaries on them. And I noticed in the last 10 years, Indians have contributed enormously to this area. And not just through the judgments itself, but many practitioners have been writing and summarizing the position. So I would say that most of us who regularly sit on international arbitrations have got a pretty good understanding of what the requirements are. And there is today convergence towards all the essential principles of a due process, whether it's a civil law seat or a common law seat. India, until 10 years ago, until 12 years ago through ENICON, was outside the mainstream. India is very much part of the mainstream now. I can say that for certainty as far as the Supreme Court is concerned, with less certainty with some of the state courts, because not all their decisions can be predicted, but I would say with confidence that the Supreme Court usually gets it right. Sometimes it slips up on stamp duty, but then it corrects itself.
Thank you, thank you. There's a young lady at the front here as well, please. And then, may I see the next show of hands? Okay, we'll go there, and then we'll go there. Oh, there's plenty of questions, great stuff. Okay, so we'll go here, there, and there. Okay, so this one, please.
Hello, everybody. I'm Muskan Gopal. I work with Sudi and Company. So this is a question which just emanates from the conversation we were having about attitudes of arbitrators and counsels. In my limited experience at the bar, I've seen a few young arbitrators being appointed. Now, my question arises from the fact that in an arbitration where the arbitrator has a lesser number of years of experience compared to the counsels, how do you ensure that the arbitrator tends to lead the arbitration proceedings rather than the counsels ending up leading it? This is a question which is open to the entire panel, whoever may want to answer.
Let's have Sadaff answer this question, because we'll do one arbitrator per question.
Thank you.
Thank you for that question. Well, I would start by saying, and it's actually something that I've also heard across the panels during the past few days. I don't see age as a particular criteria in terms of an arbitrator or as some sort of limit. Because if you really think about it, obviously there are different variances involved in terms of the sort of experience you've had. But you, perceived as a young arbitrator, you shouldn't think that you are young in the case. Don't approach the case with that mindset, because automatically you're creating a limitation for yourself, and you're already affecting your ability to arbitrate properly and efficiently and fairly, Now, I have had obviously situations where counsel has been senior than me, but I haven't felt the pressure. So it's something that it's not, again, it comes down to your mindset and reminding yourself that you're in control of your thoughts. Even if it comes up, if a doubt comes up, oh crap, I'm a young arbitrator, it's my first case, counsel is senior, I've probably, acted before them in another case, in a former career time when you were counsel. All those things are just thoughts, they're not reality. Dismiss them, get on with it. Because so I'm very passionate about being an arbitrator. And once you instill that in yourself, it's not going to affect you who is acting as counsel, their level of seniority, it doesn't matter. I've had co-arbitrators one of my co-arbitrators was the ex-attorney general. I mean, don't let age, race, or any sort of limitation create that barrier to do a good job. Yeah.
Perfect.
I can add a little bit. Same thing happens to a young judge also. When a young person is appointed as a judge, maybe in district or high court, oftentimes very senior people whom he has treated with a lot of respect and try to learn from him appears before him or her. So same dilemma is faced by the judges also. Your best friends under such circumstances would be, number one, be very well prepared. Put in a lot of effort in reading the papers beforehand. Go well prepared, you will be more confident. And two, your demeanor. You treat your seniors with respect, but don't allow anybody to dominate the situation. You are ultimately in charge of the proceedings. That message must go. It can also be done very gently. Doesn't have to be confrontationist, does not have to be any aggression, but very mild, gentle way. You make a show, you make it things clear that you are in charge of the position here.
No, I agree with you. I've had Palkiwala appearing before me, Nariman appearing before me, Venugopal appearing before me. They were much, much senior to me in age and also practice. But that has never deterred me from dealing with them with, as you write, courtesy as a court and the judge. I am in charge of the court. This is what my law. You don't like it, you do what you like it. Take the order and challenge it wherever you like. But here and there, the interesting thing is, the senior the practitioner, the more he respects you. And the more he knows how to deal with the court without irritating the court and saying, hey, I know it better than you. That is exactly the reason why seniors are given respect. And this is true of arbitration also. In fact, I remember in one arbitration, one of the arbitrators said, "Sir, you have been a Supreme Court judge. I'm not even a judge any time." I said, "Doesn't make it. We are both equal here, and there is a chair here. The chair is the one in charge of the procedural thing. Rest of it is we are independent. We can ask questions. That fact that I was Supreme Court judge is relevant to me unless you had come to my court sometime."
Thank you. Okay, we've got the next question here. Please.
Hi, I'm Arijit. I work at Skywards Law, and my question is for Mr. Thomas. There have been instances where ISDS tribunals have revisited. Is it okay? Better now? All right. There have been instances when ISDS tribunals have revisited judgments of higher courts of some countries or have ignored BITs or sunset clauses which have been terminated by mutual consent of the parties involved. How do arbitrators perceive this, and do arbitrators think that, or how do they think that they should draw a line, or when do they draw a line? Thank you.
Sorry, I think the question is, where do arbitrators draw the line in terms of revisiting matters? Is that right? So I think there are 2 points. The first is an observation made by my friend Richard Wilmot Smith. There is no stare decisis in ISDS. There is no precedent, there is no authority, there is no binding authority. There is simply the writings of learned publicists, and some investment treaty judgments or awards are afforded that status and others aren't. And sometimes it's for little more than fashion. So I think, strictly speaking, there's a right, if you're dealing with a different treaty, different state, whatever, you can revisit and you can interpret as according to that, simply informed by previous writing. If you're dealing with a particular applicable law, then arbitrators, I think, should follow the applicable law that is relevant, if it's a law that has stare decisis. So Indian law, you should seek to follow Indian law and Indian authorities and Indian precedents. Now, it's not that easy, because otherwise we wouldn't have Supreme Court judges and the like. So in fact, then you have Indian law cited to you, or English law, whatever, and you apply the usual techniques that are applied by judges and arbitrators of distinguishing cases, applying cases, whatever. And then there's always the wrinkle, subject to challenge on a ground of law in England, if it's English law, that basically, in fact, parties in agreeing to arbitration are really agreeing to there being no review of award on the basis of the point of law. At that point, you're really bound by your ethical obligations. You can't simply say, I don't like the law, so I'm going to ignore it. But some tribunals applying English law, for example, and interpreting contracts under English law, may be a little looser in terms of the way they interpret the contract within the bounds of English law, and certainly compared to what you would get if you were in front of a judge in the Chancery Division. So it's that. Some places you just have the freedom. Other places, you're simply applying the same techniques as a regular judge.
Thank you, David. Okay, what we're going to do is I saw 2 hands up there, and I saw another one there. We're going to, oh wow, this is great. We've got a paucity of time. We're going to squeeze in as many as we can. So we'll take those 2 there, then we're going to work across and take from here. I'm going to request my fabulous panel to, as they're answering brilliantly, as briefly as they can, so we squeeze in as many questions as we can. Okay, please.
Hi, my name is Vishakha, and I'm an independent practitioner in Delhi. My question starts from the start of this discussion, that when you have a mixed practice, when it's part arbitration, or if you're going to step into arbitration and you also have a counsel practice, what is the preparation, what is the difference in the preparation you undertake when you're acting as a counsel and when you're acting as an arbitrator or an adjudicator in arbitration specifically?
Sitpah, please.
Yeah, good question. So as counsel, I think it's almost a rule of thumb that the fees of counsel is about 3 times more than an arbitrator, and that's reflective of the amount of work that goes into being counsel. You have to prep, you have to strategize, you have to put the witness statements together, the arguments together, case law, and so on. So an arbitrator does some of that, a lot of that work, but not quite the same quantum. We read the papers, of course, but the whole point is that we have to remain open-minded. So when we go into the room, we may have had a preliminary view of where things lie on each of the issues and so on. We would have read it. I think that's a minimum that can be asked of an arbitrator, to have read thoroughly the papers, to know what's on each of the papers. A conscientious arbitrator would certainly do that, but nowhere near the counsel's work. The counsel knows that case inside out and knows which direction they're going to. An arbitrator does not.
Thank you. Yes, please.
Yes. Hi. My name is Abhimanyu Garg. I'm an independent practitioner. I wanted to ask the entire panel, in line with the conversation that we were having regarding retired judges or not. And so do you think in institutional arbitrations, the arbitral tribunals should be in a template in its formation or its constitution consisting of both judicial or legally trained arbitrators as well as an industry expert, so that there is more sanctity in the award? I mean, also because the conversation seems to be right now circling around the individuality of the arbitrator. You know, what their personality was like, how strict they were in adherence to the provisions or not. So the second part of that question would be, is there any challenge working with co-arbitrators? And do you think that if this was to be implemented in institutional arbitrations across the board, regardless of the claim size, do you think that it would be a more sustainable system, more sustainable awards?
Would one of the panelists like to take that one?
No, again, I think any such formulaic approach would, in my view, not be correct. The mature arbitral institutions, for example, if it's a maritime arbitration, may be minded to look for people with that expertise. And obviously, we've covered this ground in the past. The appropriate arbitrator is one who's properly trained. And whether they're a retired lawyer or a judge or a master mariner, whoever they are, the training is the prerequisite. So I think having a formulaic approach to say, like we've seen in some tribunals, to say that there should be a legal background and then plus a technical member, and applying that approach to arbitration is not the answer, in my view. It is to deepen the pool of competence and talent and allow and trust institutions over time to make the right choices. And parties have a more informed choice. Now there's artificial intelligence-based databases that can tell you the choice of arbitrators that you have. So there are many more tools that are currently there and that will emerge in future that will help you make the right choice for your arbitrator. But a formulaic approach is going to be limiting.
Thank you very much. Now, what we're going to do, because we are up against time, I'm going to make an executive decision, and it's this. I'm going to ask, we'll have 3 people to just speak their questions in turn, and then we'll just get responses from the panel. So I think, to be equitable, I saw a hand, I think from a young lady there in the middle, and I saw quite a few on this side. So is there someone in the middle who wanted to ask a question? I thought I saw a hand. Yeah, okay. So, the young man there, and then we're going to go to I'm really sorry, I'm going to have to just go with the 2 of you there, the 2 ladies there, and what we'll do, you ask the 4th one, and then we'll take reactions, okay? The 3 of you there, okay? That's it, thank you.
Hi, my name is Kanishk Agrawal. I'm practicing with Ms. Amrita and Mr. Devesh Panda. My question is this, especially in ad hoc arbitrations in India, we're often met with arbitrators who either ignore the rule book completely or they're too strict about the rule book. Even when we have Section 1 of the Indian Evidence Act or Section 19(1) of the Arbitration Act, which says that rules of evidence, for example, will not apply strictly, then how do you deal with such arbitrators where you're clueless about what to do? And what can you do, especially in ad hoc arbitrations in India, because whatever we may want to believe, they're here to stay. What can you do that such situations do not arise in the future? I mean, how can we maybe incorporate those contracts, or we have a set of rules that can apply to them? My second question, which my colleague wanted to ask me, is when arbitral awards are set aside, either on account of patent illegality or public policy, etc., how does res judicata come into play when you want to re-arbitrate that matter after the setting aside has been done?
Okay, thank you for that. Then we'll just, if the three of you could ask your questions, and then we'll take snapshot reactions from the team, who are much better than me at this, so they can do all of this.
Hi, my name is Shivangi Bajpayee. I'm working as a Dispute Resolution Associate at Chandok and Margin. My question is specifically to the ladies in the panel. What are the unique challenges that you face as arbitrators as opposed to male arbitrators? And how do you address those challenges?
Hi, I'm Palak Vashisht. I'm also an associate with the dispute resolution team at Chandok and Mahajan. My question is quite simple. I just want to know how can we make legal profession more sustainable?
Hello to the entire panel. My name is Nihar. I'm currently at Chambers of Robin Ratnakar David. I have a general question for the entire panel. I wanted to get you guys' opinions on emotional investment and the contrast in emotional investment as a counsel and as an arbitrator. I believe as a counsel we're emotionally invested in getting relief for our clients. And as an arbitrator, you guys must be emotionally invested in getting the most equitable outcome. So that's something I'm curious about. What that contrast must feel like for all of you, experienced folks. Thank you.
Thank you all. And, it just shows the quality of the younger generation of lawyers. Wonderful. Thank you all for your brilliant questions. Now, what we're going to do is, I'm going to ask each of the panelists to just give a reaction. I know there was one directed specifically at Sadaff and Sitpah, so if you could take that one. And then between David, Shreyas, VK, and Justice Kureshi, if you could just give your thoughts to what you heard, please. Thank you.
Thank you, and thank you for the question. So I think the biggest challenge is, again, overcoming your own sort of self-imposed limitations. But having said that, there have been dynamics where I have felt that, I'll just give you an example, a very quick example. So I was chairing a tribunal where I had a male co-arbitrator and a female co-arbitrator. Now, the dynamics are such that there is a lot of ego sometimes that can come into play. It's the nature of our human existence. It happens. Now, as a woman chairing the tribunal, you need to know how tough you're going to come across, and is it about coming across as tough, or is it about just, sort of detaching yourself from the situation, not taking anything personally, and coming back to the facts and the evidence. So that's how I handled this particular male co-arbitrator, because he asked me to go back to the parties based on information that he had from another case. So obviously I didn't immediately shout to him and tell him, no, you're breaching confidentiality, but he was very insistent on me going back to the parties. I didn't do that, but I took him back to our case facts and our case evidence, and I told him, please set it out. So we had a lot of deliberations based on that point. Now, when I spoke to my fellow co-arbitrator later on, she raised the question that, do you think his approach would have been different were you a man? Now, considering also the cultural dynamics that were involved, he comes from a Middle Eastern background. I suspect yes. Unfortunately, I suspect the answer would have been yes. But my number one advice, if you're a female arbitrator, don't let gender interfere with your best judgment. You really have to cast that aside and come back to the facts, come back to the evidence, and don't be afraid to be strong. Don't be afraid to put your foot down. If you know that the point that is being made that has no basis, say it. Say it obviously with courtesy, like we've heard, on the panel today, but say it. Don't be afraid to not say it, and don't be afraid. Don't come down under pressure. Yeah.
Be absolutely confident, get trained, be qualified, be excellent at whatever you do, and just say yes and do it your way. That's it.
Thank you. Okay, so then Justice Kureshi, then VK, then Shreyas, then David. Just give your reactions quickly to things you've heard.
I'll answer his question of emotional involvement, because that's a very nice question. You're absolutely right. It's a very intense job, either as a practitioner or as an arbitrator. As a practitioner, vital difference is that you want a positive result for your client, but you also want to do it within the legal parameters. You don't want to be bending the system, in most cases at least, I hope so. So far as arbitrators are concerned, that requirement is gone. You are no longer partial. You want to do the correct thing, but the additional burden of being sure that what you're doing is right. Okay, and that puts a huge load on the arbitrator. So there is a huge involvement of emotional and intense job it is. At all times, the arbitrators want to be conscientious that what he is doing is a correct thing in facts as well as in law. So that's a big challenge to do the job right. Thank you.
I'll address the question of the gentleman. I think he raised two issues, evidence and res judicata. I'll be very brief. I think it all really depends on who the arbitrators are until I think there's greater awareness and among the arbitral community, especially among arbitrators, as to what should be the ordinary standard. You're going to have these issues. As for res judicata, ordinarily, if the award is set aside, it's a nullity. You're free to start again, ordinarily. You have a problem if it's partially set aside. And that can sometimes, it can be unclear what is covered and what's not covered.
I suppose I'll take sustainability. There's a big mea culpa. I have flown too many flights, and it is totally unsustainable. It is not possible. And there is a resistance to virtual or even hybrid models, which is irrational, saying that we cannot cross-examine a witness over Zoom or appropriate technology. That thinking should change. I think the wisdom of Gen Z or what is to come, Gen Alpha, will be precisely around sustainability, and that this net zero objective that we have set the world to is a non-negotiable factor in dealing with climate change. I come to you from Bangalore, we've run out of water, it's a reality, and there's many other issues that we cannot say that arbitration is disconnected from that. So I think the issue of sustainability should be front and center to all stakeholders.
Let me try to answer the questions by plugging conferences and writing for organizations like GAR. The way in which I think I see women coming through and the change in the profession in the last 30 years is because women are now ubiquitous. My last two chairs have been women, sharing this platform with women. And one of the points that was made yesterday on International Women's Day was about visibility. And the point was made very astutely by, I think, the Additional Attorney General, as to the need for visibility, and that men tend to behave in a more visible way around the profession than women do. So I think you've started to address some of the challenges facing you as a woman by being visible, by asking the question today, because people know who you are, people have heard you. And you do that at conferences like this. And you also do it by writing and producing articles. Now, writing and producing articles is more sustainable than coming to conferences, but coming to conferences is valuable because we're social beings and we work well face to face. Now, where that comes in, because you may say, well, that's all fine, and I'm just giving a plug, but that comes back to the gentleman's question over here as to how you deal with, not res judicata, I'm not going to try and tackle res judicata. I'm giving a lecture on res judicata in about 2 weeks, and it's into relationship with functus officio, which is bothering me at the moment. But anyway, how do you deal with the arbitrator who is too strict or too loose in relation to procedural rules? Well, if you come to conferences like this, and this is also reading what people write, reading what VK writes about procedural paranoia. But if you come to conferences like this and you meet people, you start to get to know people. And you start to get to know, is someone sitting there saying, well, I'm not very keen on any of this procedural stuff. I just kind of do whatever I want. My approach to interpreting contracts is just sort of, I make it up as I go along. That's not my approach. You start to form a view as to what somebody will be like. And that's how you deal with it. If somebody is taking a particular approach to evidence or whatever, in your arbitration, it's too late. What you actually need to do is take advantage of the visibility that you've seen in your colleagues when they stand up and they speak in a conference like this, or they've written articles or papers or for journals, and think, okay, I know what my case is going to be. I will try someone like that. So the range, apart from the sustainability issue, someone's going to have to develop, I don't know, holographic conferences. I'll be retired by then. But subject to doing that, the way in which we address, or you address the issues of procedure, of how you develop your careers, how you progress your careers, is actually by realizing that this is a community. Communities of people are social communities. Come along, be visible, join in, think about what you learn about your colleagues, and practice off the back of that.
Thank you very much. It's been a wonderful session. We could have gone even longer, but as you can see, we have overrun, but we've covered some wonderful ground. Thank you for your participation. Thank you very much to you all. Thank you very much to the brilliant panelists. That's it for this session. We'll have a quick tea break, and then we come back for the next session. Thank you. Oh, now straight away? Okay. So, thank you. We are going to go straight into the next session and then have a break after that because of timing. But thank you all again. So I'm very when you're in Singapore the next time, let me know. Could I have a bite? I will be there in